Сайн байцгаана хүн үзэгчтэй. Өнөөдөр манай дефакто нэвтрүүлгийн зочноор дэлхийн алдартай том хуулийн компаниудын нэг Хоган Ловеллс компани Лондонд ажилладаг хуульч олон улсын арбитражийн чиглэлээр ажилладаг хуульч Майкл Дайвисон оролцож байна.
Майкл Дайвисон 1986 оноос хойш Хоган Ловеллс хуулийн пүүст тасралтгүй ажиллаж байна. 1990-1996 онуудад тус пүүсийн Парис дахь салбарт ажиллаж, Франц улсад хуульч мэргэжлэр ажиллах зөвшөөрөлтэй болсон. 1997-онд пүүсийн түнш болсон. Майкл Дайвисоныг Европ дахь арбитрийн хамгийн шилдэг мэргэжилтнүүдийн нэг гэж үздэг. Орос, Кипр, Турк, Вьетнам, Узбекистан, Румынь зэрэг улс орнуудын засгийн газрын өмнөөс арбитрийн маргааныг шийдвэрлэж байсан. Их сургуулиудад хуулийн мэргэжлийн хичээл зааж, арбитрийн асуудлаар олон улсын бага хурлуудад тогтмол илтгэл тавьж, өгүүлэл нийтлүүлдэг. Эхнэр 3 хүүхэдтэй.
Good evening, sir.
Good evening.
Please tell us a little bit about the company, just a general picture. What is this about?
Sure. We're a very big international law firm. We operate in 40 different countries around the world. We're the 6th biggest law firm in the world. We have over 2,000 lawyers, 800 partners, doing every form of corporate and commercial law for our clients.
800 partners means these are the professionals who owns the company.
That's right. They're like the shareholders of the company. So they're the people who own it.
To be the same share, or what? How does it work?
Well, you become a partner and you're given a certain number of shares. And as you become older and more successful, you get more shares and you become more senior. And the profits of the company are divided amongst the partners who hold the shares.
I see. And so, altogether, how many staff in 40 different countries?
5,000 staff. 5,000 staff.
5,000 staff supporting 800 partners and 2,000 lawyers.
Yeah.
And you are all around the world.
We are all around the world. We have a very big operation in the United States, here in Europe, and across Asia and the Middle East.
Particular industry you are focused on?
Well, obviously it depends where we are. So, for instance, in New York and London, there are a lot of financial companies, lots of banks, insurance companies. In Asia, it's banks and financial companies, but also manufacturing companies as well. So we cover most industries.
Mining as well.
Mining as well, particularly in Mongolia.
So that means you said mostly in America. I mean, Hogan Lovels. Tell us about that, the names, yes.
Well, it's a combination of firms that have come together over the years, okay? So the name Lowells is part of a firm that started in England in 1880, okay? So over 100 years ago. And through mergers in England and then in Europe, it became a firm called Lovell White Darrant. And then that firm became Lowells. And then 3 years ago it merged with a big American firm called Hogan and Hartson to become Hogan Lowells. Okay? Yeah.
And you are pretty much transatlantic.
That's right. So we have offices across the United States and across Europe. We're one of the very few genuinely transatlantic firms. Some firms are based simply in Europe, some are based simply in the United States, some are simply based in Asia. But we're one of the few that is genuinely across those 3 parts of the world. You know,
in Mongolia, we assume that London is one of the most financial, in particular, money market, the most center in the world. And also, probably it's because the infrastructure, like a law system, etc.
Would you agree? Well, yes, I would agree. London has always been a center for international trade. Okay. The British have always traded with other countries around the world.
Traveled a lot.
Exactly. Traveled a lot. Occupied a lot. We had a big empire, and of course that brought a lot of money into London. Lots of agreements had to be reached, and we used English law for those agreements. So London has become certainly one of the global centres for law and for finance.
You know, meeting several professionals here and visiting a lot the country, the city, all around, and I came to a conclusion that good education, good legal system were sort of necessity for keeping big empire for this country, isn't it?
Yes, I think that's right. I mean, certainly a lot of people come here for our education system from overseas, and we produce a lot of lawyers, okay, because we have a big legal system that needs to have lawyers who come through our legal system.
Why you think it's so important to have a good, a lot of lawyers, rule of laws, why?
Why do you need a lot of lawyers? The world is very complicated, and every financial system has regulations and laws, and you need lawyers to manage that and to develop that and to advise clients on what they mean. So legal education has always been very important in this country, very widely respected.
Michael, you also are practicing in France, I understand.
I did, yes, for 6 years.
For 6 years. France is a civic law system.
Yes.
It's a common law system. Hard
to do
work the work.
It is a very different approach. We have our system comes up through cases that get presented to the courts, and we then get judgments, and those judgments of the courts form our laws, and our parliament passes statutes, and they again become part of our law. The civil system is very much based on codes, okay, which have been developed over the years. So the civil code, all the relationships between people as individuals, the commercial code that governs the relationship between companies, the criminal code. So civil lawyers take these codes and apply them. But also the way we think about the law and the way that we apply the law is also very different. So yes, it was a great challenge practicing in France as a civil lawyer.
And being practicing in two different systems, do you find any disadvantage of the systems or mutually comprehension or something?
I think the English system is very thorough. People like the judges here who spend a lot of time looking at cases. But that makes the process here in our court system very expensive. To bring a case before the English courts costs a lot of money. The French system is much more efficient on one level because it is quicker, but then there is less of this sort of development of legal theory through the development of cases in the courts. So they're very different. But if you look at the world, you'll see that most countries look to either a civil law system or a common law system or a combination.
That's the case in Mongolia,
as in Mongolia, and therefore have the benefit of both. But I certainly think I see the advantages and disadvantages of both systems. Yeah.
When you get so many people, in a particular country together, there are so many relations which is to be necessarily regulated. Otherwise, if everybody goes in their own way,
there's chaos.
There's chaos, and in particular, so in the business, right?
Exactly right.
And in the businesses also, I understand you are also dealing with mostly arbitration.
Arbitration.
The business disputes mostly, right?
Correct.
Business would be good if there are no disputes.
Yes.
But in life, there are always disputes.
There's always an argument, yeah.
And what makes this arbitration system in this country so special that everybody is referring to?
Well, I think what it is if you look at an international contract between two companies, it has to be governed by a system of law. Okay, so there are certain systems of law which are used a lot for international contracts, like English law or French law or American law, and therefore, a lot of contracts are governed by English law. And if you have a big contract governed by English law, it would make sense to have your dispute heard in London. Okay. Now, a lot of big international companies don't like having a big public hearing in a court.
Yes.
They would rather have a private process and sort out their dispute between the two of them with arbitrators that they have appointed.
Yes.
And therefore, over the years, England has developed a good arbitration system which people have confidence in.
So when a dispute comes, you have two ways to solve. One is you sit with the third party, which is arbitration, and sit down together and try to solve here.
Yeah.
Otherwise, you go publicly to the court where the records are public, right?
Correct. Yeah. You can go down our court system, you can walk in off the streets, anybody can walk in, any journalist can walk in and listen to what happens in a court. And sometimes these commercial disputes, we're talking about quite sensitive information, you know, how you make things, you know, how you charge for things, and people would rather have that heard in private. I think the other difference is when you go to our courts here, you're allocated a judge, you're given a judge, and it can be any judge. And the judges here are very good. But in arbitration, you know, you have a system whereby you can help appoint your own arbitrator to determine your dispute. And that's a good thing too.
See, this system, for example, I mean, at least some countries have the arbitration in business disputes at the Chamber of Commerce, right?
Yes.
Does it work, or why it should be there? Because Chamber of Commerce may have members, and then why they suddenly will discuss, say, make arbitration court in the cases where the member is involved, and there are also non-members are there. So would be any partiality or something?
Well, I think that's certainly how it began. A lot of these arbitration institutions began as chambers of commerce. And some of them are still called chambers of commerce, like the International Chamber of Commerce, the ICC, is a very famous arbitration. Which is arbitration. But now they're very independent of their chambers, okay? And they're like separate organizations, most of them, the respected ones are. So those institutions are very independent. And they're made up with big panels of people who, you know, if you have to ask them to appoint your arbitrator, they do it very efficiently, and people have confidence in that. So I don't think that's an issue too much that they come from chambers.
Arbitration has a certain list of lawyers whom the clients will select, right? They will offer a certain probably list of.
They have a list. That's right. They have a list. But sometimes if I have an arbitration with you, you and I may decide that this man should be our arbitrator, and we would go to the arbitration institution and say we have agreed to appoint this man as
or we have agreed not to.
Or agreed not to. And we'd like you, the institution, to appoint our arbitrator. And that's another choice.
Say you and me both each nominates one, and the arbitration court itself will bring one person, so that three. So it's more fair. Your arbitrator is there, mine is there, and you're the third.
And that's good too. And that's good too when you have different companies from different cultural backgrounds, because you feel that you have someone there who understands your approach to the dispute. So people have confidence.
Are you familiar with China, Russia, and the system of arbitration?
The arbitration courts.
Yes,
the arbitration courts.
Yes, and are those China and Russia? What are the principal difference of these two countries?
Well, certainly in Russia, the arbitration courts there are the commercial courts, and they're a court system. Okay, so when you talk about an arbitrage court in Russia, it's not as arbitration as we would understand it here in England, because it's the same word, but it means a different thing in Russia.
What do you mean?
Because it's not when you say an arbitrage court in Russia, it's not an arbitration system. It's more like we would understand as a court system. They have arbitration institutions in Russia and in China. In China, they have the CTAC institution. Okay, so you have to be careful with the word arbitration sometimes, because it means different things in different parts.
Okay, where the word comes from?
Where the word comes from means arbitrage is a French word. It means to settle, a dispute, to decide. Yeah, a settlement court. Yeah, exactly.
And yet you said in Russia it is not a settlement court.
In Russia, it's more like a court with a judge. It's more like run by the state. Okay, so it's not
here you don't have a judge.
In arbitration, yes, but he's not appointed by the state. He has nothing to do with the state.
Wow. Okay. So here in the with the British system, in arbitration, nobody is nominated by the state.
No one's nominated. I sit as an arbitrator. I have nothing to do with the state, with the government. Totally independent from the government.
And who? Government. Do they nominate somebody?
When government
a court system?
Well, here in England, the judges are selected by the government, but in consultation with the legal profession. Okay, so to become a judge in this country, you have to be a trained lawyer. You have practiced as a lawyer for a long time. You become very senior and recognized, and then you become a judge. Technically, officially it's the Queen who appoints the judge, but no more does she do that. She does it on advice of the ministers and of the legal profession. So it's a very open process how you become a judge. But when you're a judge, you're paid by the state. You work for the government.
Employee of the government.
Exactly. Whereas as an arbitrator deciding arbitration cases, you have nothing to do with that process at all.
But yet your decisions will be sort of obliging.
Yes, yeah, absolutely. Because the
two parties would agree they will have to follow your decisions.
And also there are laws that say if you submit your dispute to arbitration, the parties must respect the decision of the arbitrators. Because it's a good thing for the government to have these cases decided outside the court system. The governments like that because it makes us a good place to do business. It means there are fewer cases before our court. So there's a law, a statute that supports our arbitration decisions here. And there's an international convention which allows you to take an arbitration decision given here in England and take it all around the world that have signed, or to all the countries that have signed this convention, and have it enforced there as if it was an order of a court, which is very important too for international trade.
Is it, I mean, as a rule, should every country have own arbitration?
Yeah, I think every country should have its own arbitration law that supports arbitration and encourages parties to refer their disputes to arbitration.
See, in Mongolia, for example, when the companies, two companies do some contract, they say all settlements will be done by according Mongolian laws and regulations. Yeah. But instead of, would they do it by Mongolian arbitration law? It's better, no?
They could have a contract which says this contract is governed by the law of Mongolia. Any dispute will be referred to arbitration in Ulaanbaatar, or will be heard by an arbitration panel in Paris or in London or Moscow.
Somehow all our arbitration thing is to be made by our Chamber of Commerce.
Yeah, that happens.
Is it the case of every country?
No, most countries will allow you to have your disputes referred anywhere around the world.
So but inside of the country, we want why this arbitration law should be with the Chamber of Commerce.
Exactly. There's no need for it to be with the Chamber of Commerce per se. Most countries will say you can choose whichever institution you wish.
Maybe some institutions that will have a list of lawyers who can be at the arbitrator, how you call it?
Arbitrator, yeah.
Arbitrator, yeah.
As you say, some institutions have a list of arbitrators and you have to select from that list. The Chinese Trade Arbitration Center, CTAC, has a list of arbitrators and you choose from that list.
Here in London, in your system, there were several Mongolian cases at the London Court of International Administration, eh? You familiar with any Mongolian cases?
I'm familiar with a couple, yeah.
And based on those cases in Mongolia, what do you think that Mongolia should be improving from your perspective, of course, personally?
That's a very hard question. I think there is always a need for people to understand how arbitration works, okay? Because it's a complicated process. Yes. So there's always a need for every country to have a program of education to make sure that people understand what the system means, how to participate in it effectively, to make sure that your case is properly presented, okay? And I think that's something that every country needs to work at, not just Mongolia.
So we talk about, in general, this legislative system in the country, from education to start all the way to court, right? Yeah. How to make sure that the system works? Seamlessly, smoothly, and impartial.
I think a lot of it comes from the people who sit as arbitrators in your cases, who sit as judges. Most countries always have a group of lawyers who are very active in promoting their legal system and making sure it works effectively. Some countries have been very good at sponsoring arbitration to make it a success. So Singapore, for instance, is often pointed out as a very successful arbitration centre because the government has been very active in saying, well, we must have arbitration in Singapore, we must have an arbitration institution, we must make it possible for people to conduct their cases here in Singapore. And the government has taken a very proactive interest in arbitration. Again, another example.
The Singapore case is particularly interesting because I understand Lee Kuan Yew, he himself a lawyer, studied here in England. He came back, he became president, then prime minister, and then he said that made a Singapore law system, arbitration, everything, and there is a particular provision which says if this particular thing doesn't work, then they will follow British law system. I mean, how come? He's so much confidence in that.
I mean, because Singapore was at one point part of the British Empire, they've always been used to the English legal system. So they understand it, they know it, and they apply it extremely skillfully. Another example is in Dubai. I don't know if anyone has spoken to you about Dubai, but there's an arbitration institution in Dubai and a court system in Dubai which uses English lawyers and applies English law to decide disputes in Dubai. Again, because the English system is familiar with people and therefore they understand it.
So in Dubai there is a literally British lawyer sitting there, right? The same in Hong Kong?
The same in Hong Kong, yeah.
And Hong Kong has Australian and British judge on their system.
Yeah. It's all this link of the British trade and therefore the British.
Maybe then it means that it's better to have the same system like you have and then put the British lawyer there.
No, I wouldn't say that. I wouldn't say that. My French colleagues would get very upset with me if I said that. Yeah, that would not be fair.
Or how about a French?
Well, or a French, exactly. I mean, if you go to North Africa, to Algeria and Tunisia, you will find the French legal system being applied.
And a French citizen sitting there.
Well, not a French citizen in those cases, but certainly French legal principles being applied. Okay?
There's such a thing, is, law is required. Law must be there, as we said, otherwise it will be chaos. To which extent the lawyers' legal education system here makes the British system so different? What is the contribution factor, if you would?
That's a very interesting question. I mean, I think it is quite hard to the standard to get into an English university to study law is quite high. So good students go to become lawyers. I think the involvement of firms such as ours and judges and barristers in teaching the law so people understand it from a practical perspective, I think is very important. Many of us in this firm still teach at the universities of this country, so students can understand not just the theory but also the practice of law. I think it's because you study law for a long time. It's a thorough process. You have to be trained. It takes a long time to become a lawyer. And even when you are a lawyer, you're still expected to take classes and to be legally educated.
What school you have done to be a lawyer?
What school did I go to? I grew up in Scotland, but I went to the University of Oxford. I went to Lincoln College in Oxford. I did my 3 years undergraduate course there. I then did 1 year practical training to become a lawyer. I passed some more exams. Then I trained for 2 years as a trainee solicitor, as we call it, working in different departments of this firm to see, to find out how to sell property, how to buy a company, how to sue a company, all these different things. And then I qualified. And then after 2 years I went to France. I qualified again. I got my advocacy rights. I got my arbitration exams. It's a long process to be a lawyer.
Well, it's a hard work. And plus you speak French, obviously.
I speak French, yeah.
And you study the French, or?
I passed some exams in France to become a French lawyer.
So you can be you are certified lawyer there in France. You can practice?
I'm admitted in France as well.
And because this is a European Union, or how French would accept British person sitting there as a lawyer?
I mean, because of the European Union, we have the free movement of people and services.
As soon as you speak their language, you can be sitting there.
No, but you need to pass certain exams to make sure that you have the level. I mean, if I had a French case, I would involve one of my French partners in it because they are much better trained in French law than I am. But my training gives me some familiarity with French concepts. Sure. But I would not necessarily want to appear in a French court. And
you started as a training internship, right? Yeah. Started with the same firm?
Yes, I've been here
all your life.
All my life.
Wow.
Yeah.
So at which level you become a partner?
You do 2 years as a trainee, and then you become an associate. So between 8 and 10 years, you're beginning.
But not everybody.
Not everybody. No.
To be a partner.
No, it's a selective process.
They Who will make decisions? The existing partners?
The existing partners.
Will take this man or not? They will make a vote.
Well, it used to be like that it was put to a vote, but now we have 800 partners, so we can't. So we have a process by which people are selected, and they apply.
How many of them are in here in London?
The partners? We have about 150 partners here in London. Yeah.
So those 150 partners get together here because it's possible here. Yeah. They get together or no?
We can't even find anywhere in London to have all 800 partners for one big conference. So we meet every 2 years, all 800 of us. Last year it was in the United States. So we do meet. But most of the voting that we do now is electronic. Okay, so we get do you vote for this thing?
So maybe for lawyers it's the best way to get to be partners, because you create together certain values that you can share afterwards.
Yeah. There is a thing about partnership which makes it different from a company.
I see.
Because I do think you're right. I think because you are working in the business and you own the business, it creates a different dynamic.
This is the case.
This is the case. Absolutely.
You are. You also work. You are not only creating value for the company, but as a partner, you are benefiting for the value made by other partners.
Correct. That's absolutely right.
You altogether makes the name, the reputation, right?
That's correct.
It's a good synergy, no?
It is a very good system. The partnership model is a good model for this kind of approach.
If you went through banking system, you are the executive in a bank, but now you are executive in a partner in the large commercial law firm in the country. Would you compare?
I'm much happier being a partner in the firm. I like being a partner in the firm. I sit on our management committee here. There's a management committee of about 20 partners who manage the whole business. I think it's fascinating watching how law is going to develop as a business.
So, by being so, you also are part of improving the whole legal system in the country, in a way.
I think we have a responsibility to make sure that the law continues to develop.
Because life is changing and you have to be adapted.
So we have a very active, what we call pro bono practice, whereby we help people who can't afford lawyers. Okay, so occasionally we give our legal services for free to people who otherwise would not get legal advice, and that's an important social function too.
And you do it because you are obliged to do, or because you want to do?
We think it's important as a firm that we are seen.
So you go and you say that I am available.
Yeah. So everyone is encouraged to do it. No one is obliged to do it. No one is told what to do. But most people I know do some form of free legal work for society because it's important to be seen in that way.
How do you see corporate social responsibility as a law firm?
That's important, so that we have values. So if people are involved, who are deserving, okay, who need legal advice, who cannot get it because the state doesn't provide it to them, I think it's important for us as a firm to participate.
If there was a case in your practice, a case you were very happy that you are a lawyer.
Yeah. I enjoy my job.
Okay. Was there a case where you were completely unhappy? Case you maybe lose, or you think even you win, you feel uncomfortable?
No, to be honest with you, no. I've always thought that my job as a lawyer is to defend the interests of my client. Okay,
even if it is against society.
Everybody has the right to have a point of view in a democracy. Yeah. Okay, and it's not for me to decide who is right or wrong. It is for the judge. Okay. My role as the lawyer is to present the case to the best of my ability, but to have confidence that the system will decide what is right and what is wrong. Okay?
But as a lawyer, you represent your client.
You represent your client. That is what you're there to do. That's how the system works.
Otherwise, they would not come to you.
They wouldn't come to me, and the system would not work. Because how does the judge make the decision unless the case is properly argued before the judge?
Proposed,
yeah.
Defended.
Yeah. Everyone has the right to the best legal.
Will you advise your children to be a lawyer?
That's a good question. It's a hard job. You work hard as a lawyer. Okay. If they want to be lawyers, I'd be very happy. Okay. I think it's a good profession, but it's for them to decide, not for me to impose. My father never liked lawyers, okay? So I rebelled against my father, and I don't want them to rebel against me. So I will leave.
How many children?
I have 3 children.
3?
Yeah, 3 children.
Who are they by profession?
They're all at university. One is studying philosophy, the other is will study English, and the other is still at school. So, yeah. But they're all good lawyers. They can all argue their case.
Do they live in London or in the country? Or
They go to university, one in Leeds, one in Exeter, but the other is still at school so is at home with us. Yeah,
that's great.
But they can argue their cases very effectively, as all children can with their parents, I'm sure.
My last question would be on how do you see the role of the system, the quality of law system in a developing country? And to me, for example, in many countries that doesn't.
I think for a developing country, it is extremely important that people can come to that country and have confidence that they can do business and invest and help the company develop. Yeah. And the cornerstone for that is a functioning legal system. Yeah. It is absolutely the first block in a developing country's structure that will make it successful. And it needs to be proud of that legal system. So it needs to focus on it and make sure it works.
That's exactly now Mongolia, the government is there now working. Yeah. They're working hard, and I hope Mongolia will be a better legal system than before. And it's so important to what you said today. I think it will be good food for thoughts for our Mongolian lawyers.
Well, I think Mongolia is a fantastic country with huge potential, and it will develop extremely quickly. And its legal system, therefore, needs to make sure it keeps up with its very exciting development.
Michael, thank you very much.
Okay, was that cool?
Thank you.